change in the way that injured workers were treated.
It's not just about compensation anymore. It's about fighting for what's right.
They went and got me answers. They will work very hard to resolve any issue that comes up in your case.
This is about going above and beyond. We won't stop until the job gets done. That's who we are.
Hi, and welcome to our monthly live webinar. It is a pleasure to join you guys another month again. I am beyond excited to be with Bilal Qasim, who's also joining me. Bilal, how are you?
I'm doing well. How about yourself, Carmen?
I'm doing great. I'm super excited. I can't get enough words out to just share this information. I love doing the live webinars on a monthly basis because it truly does spread out a lot of information, tips, and the best part about it, the questions and answers that people get to ask. Whether they're watching this live on YouTube or they're tuning in directly on their registration link, we are excited to have you guys on board. So my name is Carmen, your host. I also host the Work Comp Talk podcast. When you get a chance, make sure you go onto your favorite podcast app, check out the podcast because Bilal and I dive into so many other subjects regarding the workers' comp system. So without further ado, let's get started with our webinar. I am going to go over a couple of house maintenance announcements, and I do want to let you know we are recording this. So if you are not going to be able to join us through the entire webinar, don't worry about it. You'll be able to access the replay once we are done if you registered with us, which allows you to also click and be able to go back and take notes. I think it's a beautiful, wonderful option to have as soon as we're done. And if you're watching us live on YouTube, make sure you guys hit that bell notification and subscribe to our channel so you can also get updated every time we upload new content. Now, we are going to be giving you guys this promise, 3 actual promises that are going to help you. It's information we're going to share that are going to help you essentially really be successful within your workers' comp claim. However, this is educational and it does not mean that we are your attorneys and that we're giving you any legal advice. This is just for educational purposes. So we hope that this comes in handy and allows you to understand how the system works and learn how to beat the system more than anything. So, Bilal, tell me a little bit about these practical steps we're going to be doing to maximize the benefits and not just tell someone how to survive the workers' comp claim, because a lot of people do exactly just that, try to survive it. But in reality, there's a lot of strategies that go into place that could potentially help someone. So, how do we talk about the promise we have today, which are the 3 steps to maximize these benefits?
I think the first thing you have to understand that when you're surviving a workers' comp case, it really means you just kind of take what's being thrown at you and coping with it as you go along, which obviously is not great considering you're injured in the first place. You're probably not in the best place to be taking on challenging problems to begin with, let alone challenging problems that you really don't have much information about. You're not someone who's extremely competent in workers' compensation. You may be going through a case for the first time. And so a lot of these concepts are really foreign to a lot of people, and they come at a time when they're already particularly stressed out. And so a lot of what we talk about here is being more proactive in taking on your case in an affirmative way so that you're controlling the narrative and you're controlling the pace of your case, not the defense, not the insurance adjuster. We really want you to be able to understand where you are on the map and to take matters into your own hands to control your own destiny rather than just having things thrown at you and trying to cope with the outcome as it comes along. So, I think really that's the focus of today's topic.
Nice. So, what you're going to be learning are obviously timelines. We're going to be talking about the importance of wages, medical leverage in so many different aspects, right? We're going to be discussing timelines and some of the strategies that you can kind of take into place when it comes to choosing the right doctors, etc. We're going to be talking about long-term value for your case. We're going to share real stories, examples, and everyone's favorite part, we are going to have the live Q&A. And then at the end, we're going to close up with the next couple of steps that you can take to definitely be able to successfully navigate the system, knowing that you are at least trying strategies that are proven to work, and try to maximize your benefits. At the end of the day, you have rights as an injured worker, and It's your right, and we're going to share them with you. These are things that not necessarily are easily understandable when they send you all these documents through the mail trying to explain to you how the system works. So, we also have this cool feature for this live webinar. If it's your first time joining us, well, we reserve the intake team specifically for this webinar, which means you get to call an intake specialist during our webinar if you need to leave or after the webinar and get an exclusive consultation directly with our intake team, bypassing the entire wait and all of that stuff. So, not to mention, also, we have the benefits maximizer checklist, which you can get as well towards the end of the webinar. So, if you are interested in getting that, make sure you stay till the end because it's going to be a really important checklist for you to be able to succeed and successfully navigate the system itself. So, let's move on. I'm going to try to multitask here. I am going to be sharing my screen at the same time, and we're just going to be going over some of the stuff. So let's talk about, gosh, I don't know what the benefits are. What does this roadmap look like? Because I think, Bilal, explaining to someone who's new to the system, who just recently got injured, it's very difficult for them to understand what the process is even like. You're kind of just going in blindly to a total experience. You're going by what your claim adjuster is telling you, you're going by what your employer is telling you, they're sending you to doctors and stuff, thinking and hoping that they're going to be doing right for you, that they're giving you the strategies and the pathways that you need to take to be able to successfully go through your injuries and navigate and get your benefits as well, right? So, in this webinar, in which we also mentioned last time, we talked about, kind of like a little roadmap when you get stuck, when there are issues, which is what you're seeing on your screen now. Let's talk about what happens when you bump into a roadblock. What does that look like? So, what do you need to do?
So there could be a variety of roadblocks that come up in a workers' compensation case. I think the large majority that people see that are the most frustrating are the treatment that they're wanting or needing that's being recommended by their doctor is not actually getting authorized, and two, that the benefits that they should be entitled to aren't being paid to them or not being paid at the proper rate or the proper timing. And so those are typically the most frustrating components of a workers' comp case to people. Most people get injured at work. The presumption is, hey, look, I got injured. I'm an employee. I'm covered under workers' compensation. I should have my financial benefits and my medical benefits covered for me without having to fight for anything. And usually it's not that simple. I think the first and foremost, most complicated part is just getting your case accepted in the first place.
Yeah.
Surprisingly, a large number of cases are actually denied or delayed. Delayed means essentially the insurance company decides they don't have enough information to make a decision about liability, in which time they do their investigation, which is up to 90 days, and they're not paying you benefits during that time, which, 90 days of not receiving a paycheck and not receiving work comp benefits can be incredibly financially taxing on people, especially people who are living paycheck to paycheck or supporting family members and things like that. So, that's typically the most disruptive part in the very beginning. Assuming your case accepted, then we're really talking about disputes about medical treatment, whether or not things like utilization review are authorizing the care that your doctor has recommended. And to the extent that it's not, understanding what the appeals process is and how to go about fighting to get your treatment accepted, or just getting with the doctor that's actually going to give you the care that you want and the care that you need. There are doctors that are more injured worker oriented than others. There's doctors that are more insurance oriented than others, and really understanding who they are and how to get to the right doctor to help you out. I think those are a lot of the threshold issues that we see in a workers' comp case, and it kind of just builds from there in terms of complexity and problems that can occur.
Right. Which is, I'm glad you mentioned the choosing the right doctor or feeling that you are in control of the doctor in some way, shape, or form. Because I think the promise number one is we can share is controlling your timeline, obviously, right? Controlling what you can and cannot undo. In this case, you mentioned making sure that the doctor that you're with, you're comfortable. Because there's times where I feel like people will literally just stop going to the doctor because they don't like the doctor. How bad can that affect a case when you're fighting the system?
I mean, your doctor is incredibly important. They're the one that certifies you for ongoing temporary disability by way of either taking you off of work or issuing you work restrictions that the employer can't accommodate. They're in charge of making treatment recommendations. They're in charge of making recommendations for evaluations for additional specialists that are outside the scope of their practice. They get to determine whether or not you have a need for ongoing future medical care, whether you should be released from care. So really, your primary doctor, at least at the beginning of a case, has a ton of power to be able to send your case in the direction they want to. So it's incredibly important that you choose a doctor that you feel like is going to give you a fair shake and not necessarily just kick you back to work and out of the system prematurely.
Which happens a lot.
Yeah, and we had on the timeline here, evaluations, med legals, QMEs. Those are a very important step in terms of the timeline and ensuring that if you do end up with a bad doctor, you have a second shot to be able to challenge the opinion of your treating physician.
Right. Now, where does the pay come into effect? So say, for example, I'm treating with the doctor and I can't work. Obviously, I'm injured. What are some of the first steps an injured worker can take to make sure that also their wage is being protected, that I'm still getting temporary disability?
Yeah, so when you first start off with a case, you are entitled to temporary disability for a period of up to 104 weeks for most injuries. There's some exception injuries that go up to 240 weeks, but for the most part, 104 weeks within the 5-year period following your injury. Now, you get those benefits only if you have a doctor that's certifying you for temporary disability. And they certify you for temporary disability by either taking you completely off of work or issuing work restrictions that are provided to the employer, and the employer can accommodate those work restrictions. Now, there's a dispute that comes up about whether or not your treating physician report's accurate. That's resolved by another doctor called a QME. But ultimately, it's the doctors that drive whether or not you're entitled to temporary disability benefits within the maximum amounts that you're allowed.
Right. Okay. Now that makes sense why on our previous slide we did have, when there's a dispute, you then request panels. There are strategies, there are steps. The panel then essentially takes you to an appointment and you show up to this appointment. But there's a very crucial step within this part of the workers' comp case that I feel like a lot of people don't understand, and that's the timelines, Bilal. The importance of keeping track of your QME appointment and requesting the right type of doctor. I think that would be our promise number 2 for injured workers, is knowing what specialty to choose with the qualified medical evaluator. So can you start by explaining what a QME is? When does this show up in the case? And how do I choose one that's right for me? I don't know. Give us any type of advice you can in regards to this.
Of course. So, a QME is qualified medical evaluator. They're a doctor, sometimes chiropractor or podiatrist, that will actually evaluate you to make decisions about your case. And they're used when there is a disagreement about something that's going on, whether it's your disability status, whether body parts should be included in the case, your permanent disability rating, work restrictions, and things, pretty much everything. Now, a lot of people tend to say, well, I'm happy with my treating doctor. I don't necessarily need to go to a QME right away. But, sometimes it's better to get a QME sooner than later. 1, to control the specialty of the panel, and 2, to establish that you have a QME in the first place when you need it. It can take time by having to do the right steps to actually get to QME in the first place. So, it's better to start the process sooner than later. Even if your case is kind of going in the right direction, you never know when it's going to pop up and whether you're going to need it. But the QME, they're very important in the case. They don't actually provide treatment. They just weigh in their opinion on the direction of your case. And typically, the courts will look at the QMEs more favorably than a treating physician because that's their entire job. Whereas a treating physician is a doctor that's there to treat you. They can weigh in on those issues, and they do weigh in on those issues, but it's not their main bread and butter like the QMEs. So, the QME process itself is not a quick process. Getting the panel is an online process that is fairly quick, but actually getting to your appointment can take sometimes a couple of months. So, if you're at all concerned about the direction your treating physician is going in, and you're not comfortable changing your treating physician, or you can't change your treating physician, whatever the case may be, you may need to go to a QME to address your concerns. In which case, if you have an immediate need to see a QME, you may be disappointed considering that it may be, 60 to 90 days before you even get to your evaluation, and then 30 days after that before you even get to the report. So starting the QME process to actually getting a report can take months.
Right. What about I mean, for those of you that are watching this now and that's your situation, you're going through it, I would highly suggest to connect with an intake specialist or connect with any law firm. Doesn't necessarily have to be us. We're just sharing the information out there. It would be amazing for you to kind of get an idea of what are some of the steps you can take if you are disputing something, right? Or if you're unsure of what type of QME doctor you're going to choose. Like these are things that you want to ask. You want to know to do the right things because based on the decisions you make is how the outcome of your case turns out, right? So just like our little benefits, if you've won or lost, this all comes into place, right? The QME panel you're requesting then gives you a report, then gives you a rating, then it goes into negotiations and whether you settle. And it's very important to keep track of all of this, especially timelines. I would say, I think a lot of people don't understand what a QME is or how to dispute any type of situation. Like say, for example, you mentioned this earlier, Bilal. You just flat out get denied. You truly got injured at work. You submitted all the paperwork and then you get a letter in the mail saying, yeah, we're not taking your case. You have to then go into fight mode. So,
Yeah, and I think one of the important things to remember about workers' comp, as far as the timeline is concerned, it's not like a linear progression. There's a lot of types of law where there's very much, one step, two step, three step, everything goes in that same pathway. In workers' comp, the case can kind of go back and forth. It's not that clear to understand up front, and largely the direction of the case and whether you're going backwards or forwards depends on what's happening, legally and medically mainly. So, as much as we can say, hey, here's a timeline, this is kind of what you need to expect throughout the case, it's not actually that simple.
I'm glad you said that because it's very important also to keep track of everything, right? If it's not on record, then it's not really easy for you guys to then add it on record when you guys are, fighting for someone's rights. So can you explain a little bit on the importance of keeping track of any near deadlines or just, I don't know, due dates or dates of injuries, witnesses? Like explain a little bit about that part.
Sure, you want to make sure that your injury is well documented. To the extent you get injured, you want to go to treatment as soon as possible to make sure not only the fact that you're injured is documented, but the scope of your injuries. A lot of people have a tendency to focus on one body part or just one thing that's going on with them, but squeaky wheel gets the grease. When you report an injury, I don't care if your pain in a part of body is only 1 out of 10, it's still pain. And you want to make sure you talk about it and you want to make sure it's well documented. I can't tell you how many times we've had cases where an injured worker will say, I told the doctor my back and my neck hurt, same part of body. My lumbar spine and my cervical spine were both injured, but they only put my lumbar spine. And I just left it alone. And 6 months later, when they really have a problem, they're saying, well, why is only one part of my back included in this case? And there's nothing there to document that, 2 parts of the back were ever hurt, just one. And the insurance company will run with that. So you really have to make sure that the injury, the body parts are documented. You want to make sure that you have your wage records appropriately gathered. Temporary disability is based on your earnings. In general, we look at what your average weekly wages were leading up to your time of injury, and we'll use that as a baseline for calculating your temporary disability rate. And you need to make sure that that's accurately calculated. The insurance adjuster will reach out to the employer to say, hey, give me the wage information. But you don't necessarily know that the most accurate information is being provided or it's being provided on time. So you want to be able to understand what you're entitled to as far as your temporary disability rate is concerned, and be able to justify why you think your temporary disability rate should be higher than what the adjuster is paying, certainly not lower. If the adjuster is paying you more than your temporary disability rate, that may be a problem. They may ask for a credit later, but that's ultimately not something we see. Typically, it's usually the adjuster's paying much lower than what someone's earnings are. And you want to have your pay stubs, proof of earnings, whether it's tips or otherwise, to be able to say, look, I think my rate's actually higher.
Yeah. I mean, I think that's also one of the biggest issues. A lot of people don't even understand how to read a pay stub, right? They probably don't have the accurate number because they're so used to just getting direct deposit. And some companies don't even provide the pay stub anymore because everything goes through direct deposit, and they have apps, which a lot of people we know can have issues logging into those apps. They forget their passwords and it's very difficult. But This is like a quick little cheat sheet right here. How to build your medical leverage. It's one, choosing the right doctor, the right specialty, keeping your evidence files ready and updated anytime you get something in the mail, making sure you don't miss those deadlines, and yeah, just keeping those pay stubs, which you said help with the, you know, temporary disability. This is how you're getting paid while you're getting better, while you're going through, the whole entire system itself. Um, there's another promise we wanted to make here. And if this is something that sounds very similar to what you're dealing with right now and you want private consultation and just have a lot of other questions, you can also just raise your hand if you're on this and you've registered to be on the webinar. If you are on YouTube, you can also leave comments. And we do have our specialty team waiting to answer any of those questions for you as well. So talk about the ratings and the importance of the QME. I think a lot of people don't understand that that's such an important doctor, and they'll come in there hangry because they didn't have breakfast, and then they go to the appointment, show up, and they're like, well, screw this doctor. He's not even doing anything. Like, how important does this doctor weigh in on a case?
Yeah, so going back to the timeline, generally, if I were to say that a workers' comp timeline progressed in a set pattern, we'd be talking about your injury when it happens, injury being reported, first medical appointment, determining whether benefits should be paid, meaning if you're taken off of work or not. Then there's a period of treatment. Work status reports are provided to your employer. If you're getting ongoing benefits, that's how it's kept up. And then at some point, you reach a point where you're kind of as good as you're going to get.
Yeah.
And that's when you would see a QME, in addition to receiving an evaluation from your treating physician to address things like permanent disability, permanent work restrictions, your long-term future medical needs. And essentially that would be the point then where you get to settle your case. Now, oftentimes you can go to a QME earlier in the case when it's not kind of a final evaluation. If there's some other medical dispute, like if the insurance company says, we're only accepting liability for your back, not your shoulder, or we're only accepting liability for your shoulder and not your depression, stress, or anxiety that you have as a result of your shoulder injury. So those would be issues that are decided by a QME. In addition, if you're a QME, your treating physician says, hey, I don't think you need back surgery, you can go to a QME to have the QME weigh in on whether or not they think you need back surgery. Yeah. Of course, that's not going to necessarily guarantee you the surgery because treatment's still all controlled by utilization review, but the medical appropriateness of treatment is decided by UR, then whether or not the injury caused the need for treatment is decided by your treating physician and medical legal doctors, QMEs. So, you can see a QME for a variety of issues in the workers' comp case. You can see them multiple times. You can see multiple QMEs if you have multiple types of injuries, meaning, internal gastrointestinal stuff, psych, orthopedic, pain medicine. You're entitled to a QME for each specialty that's appropriate for your injury.
Nice.
But yeah, the QMEs, they're really powerful doctors. They really can make or break your case. Like I said earlier, their whole job is to comment on your case, not to provide treatment. So they write these very long narrative reports discussing in detail your medical history, their evaluation, your need for future medical care, your disability. They do, a physical evaluation if you have a physical injury, and measuring things like range of motion or your ability to squat, walk, bend over, stoop, twist your arm, whatever it is. So they really write thorough reports, and the whole idea is that you really want to end up with a good QME because they're really going to be in control of the direction of your case from the moment they evaluate you and on. And sometimes it's not the specialty that's the most important. There's a lot of QMEs that are capable of evaluating physical injuries regardless of what they are. A great example of this is back injuries. A lot of people default to the idea that, hey, I have an injury to my back, I need to be evaluated by an orthopedist as far as QME is concerned. And what you'll see typically is that a lot of orthopedic QMEs typically are the most conservative in terms of their assessment of disability, their ratings, their findings for future medical care. Whereas other specialties, for example, chiropractic or in pain medicine or physical medicine rehabilitation, are all qualified to address back injuries and do all that they need to do as medical legal evaluators. but they're not orthopedists, but they're probably going to be your best shot at getting a higher rating, having a doctor who's more liberal, who's more in favor of giving you a higher rating, more benefits, more treatment, more future medical care, and really being more on your side than another doctor evaluator would be. So, sometimes it's not necessarily that intuitive. And even within the specialties, there's great orthopedists too. I don't want to knock them. There's really good orthopedists that we use regularly to evaluate clients. There's bad ones too. There's bad chiropractors. There's bad, good chiropractors. There's bad PM&R. There's good PM&R. But it's really understanding that it's not just the specialty that's so important. It really boils down to who the individual evaluating physician is. And do you know that person's track record? As a law firm, we do. We've done this a very long time. I've represented 10,000 people at this point. I've built relationships with doctors. I've taught at CSIMs. I've done stuff, that help educate doctors. I meet with them regularly, and I have a really good understanding of who's who on the map. And I don't think your average worker really does have that knowledge. So, if you're at a QME process, I'd say, one, it's really important you understand the significance of them and at least do some research. And if you're really not comfortable with doing that, or after your research, you're not comfortable with moving forward with the QME, like definitely contact a lawyer, whether it's us or another firm, to help you out with the process before you go to the appointment. Because once you go to the appointment, you're stuck with that QME for the rest of your case.
Yikes. I mean, you mentioned a lot of doctors can be involved. I would assume it's very important for you to also keep track of what you tell one doctor. You don't change the story for the other doctor. You don't change what you tell your insurance adjuster, because that can kind of backfire on people.
Yeah, no, you're right. Look, when you go to an evaluating physician, you're not under oath. And when we just speak in common terms, sometimes we articulate stuff differently. I may tell you a story about my Thanksgiving weekend, and I may go tell, someone else the exact same story, but it might be a little bit different just in how it's presented. And the same thing happens with workers' comp. People explain what's going on with them physically or how their injury happened, and it may vary from appointment to appointment. The important part is keeping consistency in terms of the symptoms you're experiencing, the body parts and systems that are being evaluated and that you had injury to, because it's very difficult in good faith to say later down the road that, you're experiencing new symptoms and new injuries to new body parts if they weren't previously documented. Sometimes things happen where injuries build over time. I have a left knee injury, and so I use a cane or a walker or something, and so my right knee starts hurting, or my right hip, or we call them compensable consequent injuries. But just in terms of the get-go, the injuries that you have, you really have to make sure they're well documented, and you really have to try as much as possible to be careful with your words and ensure when you're going to these doctor's appointments that you're being really consistent in terms of what you're discussing with them.
Yeah. Now, if you're watching us live, I do want to remind you, we do have our intake specialist teams ready to answer any of your questions as well. They can kind of guide you in regards to how you can navigate the system specifically for your case if you don't want to share it, because obviously not a lot of people like sharing their private information on a live webinar. We do have that option available for you. And don't forget, we have the Q&A at the end of the webinar as well. So there's a lot to digest. Obviously, taking control of your timeline, your wage benefits, making sure you're getting paid what you should be getting paid, and knowing what's on your pay stub. Obviously, building your medical leverage is a very important strategy, which we just went into with Bilal, where we were talking about choosing the right doctor and speaking and saying the things that are actually hurting you, documenting everything, so that way down the road you don't get X'd out on something that you should have gotten help for as well. Gosh, how do you deal with work restrictions, Bilal? How do you deal with, say they tell you, oh, okay, you mentioned this earlier, there's doctors that are not necessarily the friendliest and they don't really care about someone's health, and they'll send you right back to work even though you're not ready or you're still in a lot of pain. How do you deal with work restrictions that you don't feel comfortable with?
Work restrictions and workers' comp is pretty complicated because it's not only a work comp issue, because the medical component, you're dealing with laws like the ADA, it's Americans with Disability Act, which is a federal issue, as well as Fair Employment Housing Act, which is a state level legislation that controls discrimination against people because of things like disabilities, their inability to do certain tasks, work restrictions, and access to the workplace. at the same time, the employer has to be really careful they're not setting themselves up for failure by, having you do things that may be in excess of your work restrictions. Because, a lot of times people do come back and they say, my treating physician was overly cautious and gave me too many work restrictions, and I feel comfortable working and doing these things. Well, what's the employer supposed to do? The employer is looking at it and saying, well, you've got this note that says you can't do X, Y, and Z. You're telling me you can do X, Y, and Z. But what's going to happen to me if you get hurt doing those things? Are you going to turn around and you're going to sue me because you're going to say, I told you to work in excess of your work restrictions? The employer has to make a determination. They have to engage in what's called the interactive process to determine whether or not they can make reasonable accommodations to have you back at work given your work restrictions. And sometimes those work restrictions are too protective. Other times they're too lenient.
Mm-hmm.
And a lot of times clients come to us and they say they disagree with their doctor because their doctor wants to send them back and they're not physically ready yet.
Yeah.
And that's probably the more common issue. And when that does happen and you are getting a work status report that's, it's not as restrictive as you'd like it to be, you can always go to another doctor. You can go to the ER, for example. You could go to your own primary doctor to see if they'd still be able to write you work restrictions. But you can also go to the QME and have the QME address the primary treating physician's work restrictions. But the idea is you want to establish care and you want to establish work restrictions that are supportive of how you feel and your ability to work, and not go back prematurely to injure yourself.
Yeah.
Major issue though,
Mm-hmm.
sorry, I was just going to say the major issue is if you don't have access to another physician, you don't have access to an ER, you don't have access to a QME yet, what are you supposed to do when you have work restrictions that are so, I guess, lenient or light that if you go back and you go to work, you're going to get hurt?
Yeah.
And a lot of clients feel scared because the reality is if they're cleared for work medically and they don't go back, and the employer offers them modified work within those work restrictions, that they may be ultimately terminated or let go for job abandonment.
Mm-hmm. Yeah.
And
Well, I'm pretty sure we're going to share a couple of stories coming up within the next few slides. I do want to remind everybody that you do get the Benefits Maximizer checklist, which is a little summary of some of the things you need to keep in account for, and making sure that, you're crossing off everything in your checklist and knowing that you're going on this right path. Bilal, you mentioned, something that brought up another thing, self-inflicting damage, the infamous social media pitfalls that, you're sitting here trying to get, your work restrictions, but yet saying, oh, my back hurts or I can't walk. And then you go on social media and you're in the beach, swimming, doing laps, playing volleyball. Like, the importance of not creating those big mistakes. Can you give us some examples of people being caught on social media when they said they were not good for work?
Oh man. I mean, I don't want to go into case specifics, but sure, that does happen. I've had a couple clients over my years of doing this that they've been caught working second jobs when they're supposed to be off of work, and not jobs they had pre-injury. They were working one job, they got injured, they were collecting temporary disability, and they decided to go get a second job so they can double up on their pay. Which, I'm not a huge fan of insurance, but still, you got to play by the rules, and that's not okay. I've seen people get into trouble for that. I've seen people who have, gone to a QME or gone to their treating physician and said their work restrictions should be more significant because they have really bad injuries and they have really, significant functional limitations. And it turns out, the insurance company hires an investigator to follow them around and they can do everything they said they can't do, things like that. We've had clients that do get caught on social media posting their earnings or going on vacation and traveling or doing things that they said they couldn't do as well. And, anything you say and do can be used against you. That's not just in criminal law, that happens to apply in dealing with insurance companies as well for workers' compensation. And look, as much as I'm a man of the people and I wholeheartedly believe injured workers are getting screwed every day, I also want to ensure that injured workers have a fair shake. And anytime there's fraud, anytime people are lying, anytime people are creating problems in their cases, it really kind of sours experience for the rest of the injured workers out there who are really just trying to get by. And so, we'd say just be honest about your limitations, be honest about what you can and can't do. Just be upfront. Be a good person, And hopefully the idea is that good things will come to you. Not all the time, but that's why there's lawyers here to support you.
Yeah, no joke. And if that's your situation, if you've had all the best intentions to go and do the right things for your case, but the system has just been cheating you out of it and you've been struggling, this would be the moment to speak up and say something and connect with someone. And I think a lot of people fear connecting with an attorney because they feel like they're going to have to pay out of pocket. But hint, hint, secret number 3, it's based on contingency fee. Can you explain a little bit of how someone would hire an attorney if they're obviously injured at work?
Yeah, so pretty much any work comp attorney in California at this point is going to be contingency fee based, which means they don't take a fee up front. All fees in workers' compensation have to be approved by a workers' compensation judge, which means if a lawyer is asking you to pay up front or asking you to pay them on an hourly basis, like I said, up front would be something called a retainer payment, where they draw from it, or they're asking you for an agreement to a flat amount, regardless of the outcome. Those are all big red flags. Lawyers in our industry typically, request 15% of whatever the award is or settlement is at the end of the day. And that's fairly standard. Things like litigation costs, if we hire, vocational experts or we need to get records and things like that, those are not costs that get passed on to the client. So really, it truly is a situation where if you as an injured worker benefit, the law firm benefits too. You'd never be in a situation where, the lawyers are collecting fees or money from you and you get nothing.
Yeah.
That just doesn't happen in workers' comp.
Luckily. So for those of you that are watching, remember there are consultations open as soon as we end this live webinar and even during. So tap that button, call the number. And because you're part of the webinar, just mention it to them. Hey, I'm listening to the webinar. I need help now. You get priority. So you can ask for that checklist as well, the ultimate checklist for you to make sure that you are crossing all of your T's and dotting all of your I's. That's also very, very helpful. And I guess now I would like to pick your brain before we move on to I like picking your brain and sharing real life stories. I think those are very valuable. And we're almost getting close to the end of this webinar, but I do think it's also important to highlight the importance of ratings. I think a lot of people don't understand how a settlement comes into play once you've discovered that the insurance company has accepted your case and you've fought with them on certain issues. You went to the QME appointment and then all of a sudden you're hearing this word ratings and you're like, what does that mean? And how does that affect a settlement below?
Yeah, I mean, look, when we're talking about, ratings in particular, is applied to this slide here, mistakes in workers' comp come up a lot. There's a lot of mistakes that can be fixed. There's a lot of rules in workers' comp that are actually fairly lenient and give people an opportunity to kind of take a second shot at things. There are rules and laws that are very steadfast and serious, statute of limitations for one. Not filing your application within the allotted legal time to do it. Those are firm. You can't make that up. That's, if it's too bad, so sad, it's passed. That's what it is.
Damn.
Similarly, it can go for ratings too. Permanent disability is assessed typically at the end of the case. And largely it's assessed based on the accepted body parts. And, to the extent the doctors choose the ratings, it's up to the doctor to be on your side, basically. So, it can be really hard to fight a permanent disability rating if your treating physician was the wrong person, your QME was the wrong person, and you've already been to evaluations, your case is already almost done. It's very difficult to undo that. Ratings are decided by what's called the AMA guides for rating impairment. It's a green book that the doctors have, and the doctors basically look at this book to assess ratings based on things like functional limitations, movement deficits or disorders, or surgical outcomes, or just the existence of certain conditions that are there that have percentage disability ratings attached to them. And so this rating guide is essentially a guidebook to let the doctor pick and choose the ratings that are most appropriate to reflect the permanent disability you have that can't be fixed through treatment. And so, it's hugely important you go to the right QME, you go to the right treating physician, because they're the one that's deciding those things. And to the extent you go to the wrong doctor, they give you the wrong ratings, your ship's kind of sunk at that point. We
Yikes.
can try to cross-examine the doctor, we can take their deposition, we can request supplemental reports to ask them to address, or readdress permanent disability or body parts that they may have skipped over. But, the doctors typically don't like to change their minds absent new information, meaning if, a diagnostic like an MRI wasn't provided to them, or an EMG, or, they didn't have operating report or aware of a surgery that happened. Those are things that may impact ratings. But if the doctor's seen everything and you're just stuck with a conservative doctor that does not want to give you a high rating, oftentimes it's near impossible, or certainly very difficult to change that doctor's opinion. And as long as the doctor is using their reasonable medical knowledge to find that within some reasonable level of probability that your injury is the way it is, and the disability rating is the way it is, that it's very difficult to change their mind or win, because essentially they're saying, well, I'm right because I'm right. And how are you supposed to argue with that? It can be near impossible. So, my one word of advice in terms of not making mistakes is ensure you're getting to the right QME, because the permanent disability is the main basis about which the value of your case is decided, and you can't mess with that.
Can you share a story with us, Bilal, where you were able to kind of navigate, I guess, the QME rating and successfully secure a stronger settlement?
Yeah, I mean, there's one guy, he'd gone to an orthopedist QME. He had a cumulative trauma for his lumbar spine. He was a chef, if I remember correctly, in San Francisco. And he'd gone to this awful QME, and this awful QME said he didn't have a work-related injury. Yeah, the QME, he was an orthopedic surgeon, said that he didn't believe in the concept of cumulative trauma, the idea that you can have a repetitive stress injury to your orthopedic body system, bones, joints, ligaments. So by definition, in workers' comp, we have cumulative trauma. It's the idea that you have small traumas, not necessarily specific incidents like falling off a ladder, where over time, wear and tear based on a profession can cause injury. And this doctor said he just didn't believe in that as legal concept, and said our client didn't have injury. And unfortunately, it wasn't just like a sprained back, it was a herniated disc, and my client had failed back surgery, and he was actually on a pain pump for his spine. He was in significant pain. If I remember correctly, he was like 35 years old. And so he's being told he's getting nothing, absolutely nothing from his case. And so I took the QME's deposition. That's obviously how I found out the QME didn't believe in the idea of cumulative trauma. And I was able to make it appear such that the QME was so prejudicial and his report was so biased and inappropriate, not only just for that, but also based on the fact that he said he didn't care what the injured worker's work duties were, because he didn't believe in cumulative trauma existing. So essentially, the deposition made the QME look so bad that I was able to get the QME report thrown out. Now, my client didn't get everything they wanted, because there was a lot of risk going forward that they may not get a better QME. But we ultimately settled the case for pretty high six figures,
Nice.
which, certainly not what the case is fully worth, but, going from zero to, several $100,000 is a big deal, all from one deposition. But,
Right.
that was a challenging deposition, and not all challenges to QME reports have that same result.
Right.
So, that was kind of like a really good outcome, and I was really happy with the work I did to help this person. But some QMEs, they're just going to defend their position, and maybe they wouldn't have said stuff as poorly as this QME would have, and we would have been stuck with him still.
Mm-hmm.
So, I think you just have to be really careful about picking the QME, because sometimes we can win those fights, sometimes we can't.
Right. But I think it's important, right? If you just so happen to be with a bad QME, but your medical records back up what you're saying, doesn't that weigh something? Doesn't that help in some way, shape, or form?
It does, but insofar as the QME, and look, when I say the QME gives a bad rating, the guides very clearly define when ratings are appropriate and why. The QMEs do have flexibility in how they assess ratings and ranges for certain things, but the guides are pretty strict in terms of how permanent disability is assessed. So objectively, if you meet the criteria for ratings, you should have those ratings.
Hmm.
The issue becomes there's case law and other factors that can be used to give you a higher rating than you would normally be entitled to. In my opinion, is that quite frankly, work comp is garbage, right? The amount you get, the work comp you, the benefits you get paid through workers' comp are near worthless these days. It's certainly not enough to justify the injuries and the aftermath that people go through. And
Right.
so my opinion is that a higher rating should always be given to the extent possible, because people deserve it. Work
Right.
comp hasn't changed in a long time and it's really under delivering to people in need. And so, from that perspective, you want to make sure the QME is going to be that person who not only just goes and gives you the most basic, bare bones, boring rating possible in the AMA guides, but they knock it out of the park. They give you every rating percentage possible to ensure that you have the highest disability rating possible so that you get the most compensation possible. And
Right.
anything less than that is a loss.
Hmm.
Because work comp already is a loss. We're just trying to make lemonade out of lemons, but it's still really bitter. Put it that way.
Very. The patterns, timing, match specialty, consistent documentation, and our intake team is ready to help you map that out. If you are interested in connecting with our team, I do highly suggest you guys give them a call or on the chats. I see the chats very quiet right now, but I do want to start asking those that are watching us either live on YouTube or if they've registered for the webinar to start getting those questions ready, because we are getting to the moment where we're going to have the live Q&A where you get to ask Bilal all of these questions. And I was going to have you share another story, Bilal, but you pretty much shared two amazing stories, right? You had the chef and then the other gentleman who got caught working his second job. So we're just going to go straight into what would be our next section, which is the Q&A. And again, if you don't want to share any private details, please don't. We don't suggest sharing all those private details in the live. But there are questions, for example, that come into play specifically that a lot of people wouldn't even bother to ask or wouldn't even think about asking because they don't know what they don't know. And that's your favorite phrase. And I take it from you. So I guess any question goes here. But if you can kind of elaborate, what does you don't know what you don't know, and how does that play into asking the right questions?
Work comp is a system of opportunity where if you know what you're doing, you can get things right and you can get benefits paid to you. You can get the right evaluations and the right treatment with the right doctors. But if you don't understand the system, you don't understand how to navigate it, you're missing out because you just don't understand the scope of what you're entitled to. And if you don't understand the scope of what you're entitled to, how can you work towards getting those things? So, I
Right.
think for a lot of injured workers, they just kind of go in blind. Work comp is not something necessarily that's widely discussed amongst people when they enter the workforce. And there's certain professions where it's more frequently brought up than others. I think firefighters, police officers, construction workers, they're all more far likely to discuss workers' comp than, say, an administrative assistant in an office. But they're all still the same. And, some of the most significant injuries I've seen have come from professions that are typically not that dangerous or certainly not risky, at least is the perception. So, I think a lot of people don't necessarily feel like they're ready for workers' comp because it's just not something that's on their radar until it is. And when it's there, it moves fast. And to the extent it does move fast, you got to know what you're doing and you have to understand how things work to be able to maximize the benefits and the treatment that's possible for you. And I also feel like too, once you do know workers' comp, sometimes I think it's easier to understand that a win doesn't necessarily feel like a win. A lot of people go into the system thinking that they're going to get everything they want, and they're often left feeling like they are getting a total loss, that they're not being compensated, that they're not getting the care they need. And, that's unfortunately a very common place for people to come out of a workers' comp case. And it's just the system we have. But, being equipped with the knowledge and understanding where you are on the map and how things work can be a huge advantage to getting you as much as possible.
Right. It's a lot. It's a lot to dive into. We do have a couple of questions coming in, Bilal. It says, this is from Cripe 1985. It says, long story short, I was made a settlement offer at 20% loss, and I wanted to get a final evaluation for peace of mind and a better overview of my injury. Then the adjuster said, I rejected the offer because I took too long to answer. Is that even legal?
Settlement offers can be made at any time. They can also be pulled at any time. Once a settlement offer has been made, there is no obligation to actually stay true to your word and accept it or decline it or put it out there or not put it out there. Usually, at least as a lawyer, it's very poor form for me to make a settlement demand on behalf of a client, intending for it to be limited and not give that instruction as well. Usually when we make settlement demands that are contingent on things, either time or events, we usually say that. We usually say, hey, insurance company, this settlement demand is only good until the QME appointment. If you guys don't accept it, then it's off the table. Or, hey, adjuster, this settlement offer is good, but only if you guys make a decision in 10 days. So, I would say if the adjuster made an offer to you and then subsequently you took a little long to accept it and they said it's no longer available, I would say that's pretty rude and poor form, but not illegal. It's just unfortunate. Now, I guess depending on what your rating is, if you're feeling like the rating wasn't appropriate because it's in a rating that the adjuster came with, you always can go to a QME evaluation or have your PTP address your permanent disability. It sounds like maybe this was an offer based on an estimate before you had that opportunity. And so, there's obviously risk going forward, whether or not, the QME is going to give you a higher rating than what the adjuster estimates if you're not there yet. But, at the end of the day, peace of mind is important. And if you feel like the adjuster is being disingenuous or offering you less in your cases, which with surprise, happens a lot, then, maybe don't feel too bad about not accepting that offer and, go do your evaluation.
Yeah. Okay. Thanks for that question. We have another one from David Ramirez XV2SN. Yeah, it's via YouTube. That's why the names are all crazy. Okay, so it says, I got a question. I was recently denied my psych treatment from my injury from falling from 10-foot high, which I'm suffering from PSD, which the doctor understands and ordered. I should be getting an independent medical review along. My attorney should also be requesting this, but I'm suffering with, it says, I'm suffering this real thing with, I can't even drive. I'm scared of driving over the mountain because I think I'm going to fall again. However, they're not approving the independent medical review.
Yeah, so just a few comments on that. There could be a number of things going on. It sounds like you have a treating physician who understands you have a psychiatric injury. It's a compensable consequence of your physical injury, which is super common, especially if it's something very traumatic. Now, when you talk about psychiatric injury as a compensable consequence, we treat psych injuries as a body part or system, which means that part or body or system should be independently accepted, meaning liability accepted by the insurance company to trigger a request for authorization going to utilization review. If utilization review denies the psych treatment and psych is an accepted body part or system, then IMR, independent medical review, is the process by which you appeal denials. Now, your utilization review decision should have been communicated properly to your doctor and to your lawyer if you have one. Procedurally, if there's a defect in the utilization review, you could use that as an excuse to proceed to the appeals board to try and get the treatment authorized without having to go through IMR. But if the utilization review decision was appropriate procedurally, then your only recourse is IMR. But to the extent you have an IMR appeal pending, you do want to make sure once you get your IMR decision back, if it's against you, that all the necessary medical information was provided to IMR. There's a list of documents that IMR actually reviews that goes with the decision. So you can make sure that, hey, did the adjuster really send everything they were supposed to? To the extent they didn't, you can challenge the IMR decision. But if the IMR decision overturns the denial and you get your treatment, great. If it does not, unless there's a change in circumstance, the utilization review decision denying your care would be good for up to 12 months, which means you'd have to wait. A trick around this is your primary treating physician could potentially use the basis for the utilization review denial to establish a change in circumstance. We see this a lot with physical injuries where the doctor will say, hey, this person needs a back surgery. Goes through utilization review denies it and said, well, no back surgery until you get an MRI. Instead of waiting 12 months, the treating physician can simply go and request an MRI and then, get the MRI and then resubmit the request for surgery because it's a change in circumstance. It was material to the decision. So you can get away with having to wait for that 12 months in order to take another shot at it. But ultimately, treatment denials can be problematic. If you haven't seen a QME yet in psych, and you have a QME in orthopedics or pain medicine, chiropractic, whatever it is, you could certainly try to go to a second QME. And I've had cases where even though treatment has been denied, the QME will say that the person is not MMI and won't be released for permanent work restrictions and deemed permanent stationary until they actually get that treatment. And they'll keep them on things like temporary disability, which obviously frustrates the insurance company. So there's litigation tactics you can use to put pressure to authorize care, even if it's maybe not authorized, or if treatment is denied, there's ways around to fight it, certainly either through IMR or looking at the UR decision to see whether it's procedurally defective. So, you're not alone, and a lot of clients feel this way, and a lot of times we do see treatment getting denied, even if it's the bare minimum of what people need, unfortunately.
Dang. Okay. We have one final question, Bilal. This one's coming in from Sutton. No worries. What about if they turned off your benefits stating that you denied modified work, but you can prove that you didn't deny modified work and you have a follow-up doctor's appointment that gets you cleared for state disability, plus multiple QME reports stating that they are TTD? When should I finally go to trial for the benefit portion? Is that going to make them liable from that point forward, plus penalties? Am I entitled to anything?
Yeah, it sounds like you're ready to rock and go to trial. If you've got reports that establish your right to temporary disability during the period in question, they clearly identify your work restrictions, you have documentation to support that the offer of modified work was invalid, meaning either it just was never made to you in the first place, or that it wasn't in line with the work restrictions you had from your doctors, you'd certainly win on an argument for back pay for the temporary disability. You would be entitled to penalties. Typically, if it wasn't justified, we would ask for a 25% penalty. When you file for a hearing at the Work Comp Appeals Board, at least for trial, there's two types of trials. You can either do an expedited trial, which means the first hearing is the hearing that you address everything, or you can file for what's called a mandatory settlement conference, which isn't a trial. It's an opportunity to try and resolve the issue. And then if you can't, then you get set for trial. Now, the appeals board will tell you that you cannot address penalties and sanctions at an expedited hearing. So to the extent you are asking for penalties and sanctions, you may want to consider filing for a mandatory settlement conference first. If just simply getting the benefits paid to you is the most important part, regardless of the penalties, you could always go to an expedited hearing just to get ready to rock immediately. And then you could defer the penalties issue until later. At the same time, depending on the scope of what your employer did or didn't do, failing to offer you modified work or lying and saying they did when they didn't, or making up some story to otherwise discriminate against you can be grounds to file what's called a 132A petition, which is a petition that you've been discriminated against or retaliated against because you pursued a workers' compensation case. So could also potentially be a failure to accommodate case under federal law, ADA, as well as state law under the FEHA. So
does that happen a lot?
Yeah, all the time. Of course, for FEHA and ADA, there's different rules that apply for different sizes of employers, but we see everyone from all sizes of employers, whether it's mom and pop shops to big companies, that are discriminated against because they have limitations. They're told they're offered modified work when they're in reality, they're not. So there's something called the odd lot doctrine in workers' comp that puts the burden of proof on the employer to prove that they could have offered you modified work or did offer you modified work. So to the extent that you say you have proof they never offered you modified work, go get your benefits, man.
Seriously. I think there's just a lot, that comes along with the workers' comp system that people don't know. And just by sharing these 3 steps to maximize your benefits, I think it's very important for people to understand if it gets to the point where it's so complicated and it's just overbearing, overwhelming. And on top of that, you still have to stick with making sure you're taking care of your family and your priority of your health so that you can get back to work again as much as you can were prior to the injury. Man, why would you not even hire an attorney to do everything for you? Because it's a lot of work just to keep up with all of this, you know? So I think we have one final action for you guys, which is gather your documents with this checklist we can provide for you at the end. Book an intake call. I swear, consultations are free. You can get so many questions answered. You can actually start sleeping at night, not necessarily keeping yourself up like, what about this and what about that? Like, truly speak to the ones that do this for a living. And obviously, keep your phone handy because if you called us and we're going to connect with you, then you want to speak to us. And again, if you have a milestone, if you have something coming up, a hearing, a trial, a QME appointment, and it's less than 14 days, mention that to the intake specialist because as we mentioned earlier, those statute of limitations, those deadlines are serious. And what happens, Bilal, if you haven't had a QME and then someone that has obviously, I'm sure you have a list of, oh, this is not the best QME. We don't really like this QME. What can you do for someone before they go to their QME appointment?
I mean, if you have a QME appointment and you already go to the appointment, you're stuck with that QME. If you haven't gone yet and you got the QME before you retained a lawyer, there is a way for us to get rid of the QME and start the panel process over to get you a new one. So to the extent you have a QME, but you haven't been to the appointment yet, there's still time to get away from it if it's a bad QME.
I would definitely want someone to tell me like, hey, you're going into the lion's mouth, get out of there. Like, don't even go that route.
It's common. We've had clients who call us just because they do have an upcoming QME and they're like, what's this about? And there's been times where we're like, dude, this is terrible, evaluator, don't go, and it's been like sometimes days before,
Yikes.
So yeah,
Damn.
it happens.
That's awesome. It's awesome that there's people like you, Bilal, that kind of, steer people into the right path before they go into a big old ditch and then they get stuck with that, right? So again, if you're interested in getting the checklist, it is going to arrive to you via email. If you didn't register for the webinar, you're watching live on YouTube, make sure you leave it on the comments and we can connect with you as well and send it to you. The replay is also going to be available for a specific amount of time. So if you were just jumping in and you missed the first part of the webinar to how crazy the workers' comp system works, then you definitely want to check out the replay as well. And yeah, thank you guys so much for joining us. It was a pleasure. We do these once a month and we hope to catch you guys on the next one. There's just so much to dive into that we can be here for hours. Unfortunately, we're just getting ready to, help anybody and as many people as possible, but please do something about it. Don't just sit there thinking that this problem is going to go away or it's going to fix itself. The system is like you mentioned earlier, Bilal, it's not there to give you and make you rich and give you all the answers and all the solutions. It's a pretty crazy, hectic system, to say the least. Is there anything else, Bilal, you'd like to share before we say our goodbyes?
No, maybe on the next episode, but there's a lot.
Definitely check out the podcast. We do also post on a weekly basis some of the frequently asked questions. And if you have a question as well that we didn't answer in this webinar, go into the YouTube videos for our Work Comp Talk channel. And on the podcast, we might even pick up your question to be the next episode as well. Because again, there's a lot to talk about. So thank you, Bilal, for joining me. I will catch you guys on the next one.